What's up, everybody? Welcome back into another episode of The Lawyer You Know. And this was pretty heavily requested. Lori Vallow is still in our lives somehow, even after being convicted of doing the worst thing imaginable, as her Arizona trials are heating up and about to go to trial in the beginning of April. And she had a hearing in which she is representing herself pro se, because she is going to be representing herself pro se in these Arizona trials. And this was the pretrial hearing to deal with the issues that are still open and the issues that are still going on between her and the state. They're also going to talk about some procedures, some things going on as far as housekeeping matters before the trial. We are going to watch parts of this hearing together, see how Lori Vallow did as her own lawyer, and see what we think she's going to do and what we think it's going to be like in trial. So why don't you guys hit that like button? Let me know if you're still following this case in the comments, and make sure you subscribe to our page. So we are in court. This is Lori Vallow's judge, and they're going to handle a bunch of different issues. We're going to learn some information that's just going to talk about how wild these trials are going to go. They're doing two back to back, maybe, because we start discussing that issue a little later on in this hearing. But Lori Vallow speaks quite a bit. She's not sitting there quietly like she did in her trial in Idaho. And the jury is going to hear her voice. The jury is going to get a vibe, for lack of a better word, of Lori Vallow, and they are going to determine what they think about Lori Vallow and can they believe Lori Vallow based on what she's saying. So let's take a listen here. They talk about the media request. There is going to be live streaming on a 1 to 2 second delay. Basically, Court TV will be running the pooled camera, but Lori Vallow objects to some of the media attention and maybe the live stream and just how it's going on in the case. And she brings in some experience from her Idaho trial and some arguments her lawyers made that were successful in the Idaho trial to get cameras out of the courtroom. So she was listening, she was paying attention, and she makes some similar arguments here.
Objection. Do you have anything? I know the defendant filed an objection. I've read your objection. Do you have anything you want to add to that?
Yeah, Your Honor, I'd just like to add some case law to that. Shepard versus Maxwell, 337 U.S. The United States Supreme Court, Mr. Justice Clark, held that failure of the state judge in murder prosecution to protect defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process. So that and Arizona versus Cheney, which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced to the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Your prior attorneys had filed a series of objections to media coverage being allowed in the courtroom, and I made a prior ruling that was filed back September 4th, which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow.
So then we jump ahead to kind of her next argument. They talk about the 1 to 2 second delay, if that's possible. But Lori Vallow jumps back in and says, they better not zoom in on my face, Judge, using the argument, like I said, that her last lawyers used. But we also saw some research, some case law. Her standby counsel definitely seems to be helping a lot more than I've seen other standby counsel help. So that's good. Hopefully it keeps the train on the tracks a little bit.
All right, let's get down to business on some of the.
Your Honor,
yeah.
Could I just add that we want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think.
All right, well, my draft already includes that there'll be no zooming in on counsel table, anything on counsel table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that.
So he says, we're going to make sure that doesn't happen, but we are going to allow the cameras in the courtroom. The state thinks the first trial is going to go about 2 to 3 weeks. There's 2 separate victims, so they're handling them separately as at this point. She thought it was going to be 2 to 3 weeks when Vallow was represented by counsel, but as we all know, Pro se cases seem to last a lot longer. The judge starts talking about jury instructions and procedures, and they anticipate losing a lot of people because of the media coverage and people already potentially forming an opinion about Lori Vallow or this case. He does want to include her name on what they send out to the jurors, which I find interesting. I can see arguments on both sides. I would probably lean on the side of let's go ahead and get it out there. If somebody's got a problem or a thought about this, we might as well find it out now, not later when they find out what her actual name is, because they're going to find that out anyways. But Lori Vallow has an issue with that. And it's not a bad idea, or it's not a bad argument. But again, whether it happens when they first send out the jury information forms or questionnaires or when they show up at court, this could be an issue that does happen in the case. Let's take a listen to her make an argument here.
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is. And there's people that will want to be on this jury just for this purpose.
So she's worried about people forcing their way on the jury just to convict her. It's an interesting strategy here. She's speaking in third person. We can put the name on there and they know who that person is and speaking about herself as if she is not herself while she is playing lawyer here, representing herself. But I got to be honest, so far sounds fine to me, making cogent arguments. Definitely better than some of the other pro se defendants we've seen in the past, a la Daryl Brooks, Ronnie O'Neill, and the such. I mean, Tellez, was that his name? Tellez was a lawyer in Nevada, New Mexico. All these cases are running together here now. Was not great, but he was actually a trained lawyer, even though he was not a trial lawyer. So we'll see where she falls on the spectrum. We'll have to do rankings at some point for pro se litigants representing themselves. But so far, she's definitely in the upper half. How high will she go? Who knows? I am also sure that there are people that already know her story and know about her case, that this will just enrage them. How she's acting, how she's speaking, how she's living her life, knowing what she's already been convicted for and now accused of here. So there's going to be a lot of that. And none of those people should be on this jury. We should be able to admit that. Those of us who have watched as much of the Lori Vallow saga as we could, especially watching the entire trial over in Idaho, knowing what that result is. If you already have some thoughts and feelings about Lori Vallow that you think were confirmed with that first trial, not right for these trials in Arizona. Will they be able to flesh that out in jury selection? I hope so. I hope the state does a really good job about it, knowing there's not a defense lawyer there. And I hope the judge as well really tries to get out those people that are obviously biased against Lori Vallow prior to even listening to any of the evidence in this trial. Because you can understand, if they know about the first trial, they're like, she's a horrible person. Obviously, if she did what she was accused of in the first trial, she did what she's accused of in the second trial. That's not really how it's supposed to be. They have to prove every individual case on their own.
Well,
It's going to be complicated.
all the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer.
I've never done a trial with e-questionnaires. She's going to talk about how many potential jurors they went through in Idaho. I forgot this or didn't know this, but wild. And I can understand why they want to start the process with e-questionnaires. Of course, they are going to do in-person questioning as well.
Name is going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial. So
1,900 jurors. It's a lot of jurors. A lot of jurors. That was Idaho, smaller jurisdiction. I feel like that case was more widely spread and known about, and people had feelings about and documentaries about that were focused really on those Idaho charges. I would think you wouldn't need as many in Arizona. Maybe I'm way off base.
it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether
Sure.
So that would take forever, obviously, to voir dire 1,900 jurors. But what I think they should do is you start with a big group, you whittle it down, then you individually voir dire a much smaller number, maybe 40, 50 jurors in order to get to that number you're looking for. You can't possibly individually voir dire 1,900 jurors. So whittling it down to eventually individual voir dire, which I will tell you, we've had cases where we've had to do that. And a lot more information comes out when you have one person sitting there in the chair and you're asking them questions. They're not worried about what anybody else is going to hear them say. So that is appropriate in certain cases. And I would say this is one of those.
Do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there.
So opening statements, April 7th. Interesting. So we're going to have this and Karen Reed going on at the same time. Always fun following two trials. I want to say during Karen Reed's first trial, was Chad Daybell's trial going on at the same time? I think I did two at the same time back then. I don't know. We'll see. We'll see how all that goes when we get there. I'm going to hop ahead to the next kind of set of arguments that Vallow gets into.
Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion. So we would just like them to please turn over whatever they have left.
All right. And I'll ask the deputy county attorney. I imagine some communications are by phone. So in other words, we're not captured.
Correct, Your Honor.
All right. Based on the states of Vallow, I don't know. I can't tell them to turn over something they say they don't have. So I'll find that the state, based on their Vallow and officers of the court, have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one.
Pretty good argument, right? It's online. I've seen it. Everybody has it. I want the official one from them. How are they going to say they don't have it? It's a pretty good argument that she makes. Is it going to make a difference in her case? No. But why aren't they turning it over? I don't know. But it just, state attorneys do stuff like this all the time. It's like, we know you have this. The other thing, they're like, we gave what they have. And the judge is like, I'm going to take them at their word, which they could be telling the truth. But in cases where you don't actually have that, then it becomes problematic, especially when you have prosecutors that are not trustworthy.
To be turned over to the defense.
All right. So do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed. This is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one. And my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
I mean, we disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your paralegal provide a Bates number or something so that maybe the defense just has overlooked it?
Let me see if we can find the actual
Maybe the discovery notice.
discovery letter.
Okay.
It's like, we're not sure. We've turned over a lot of things. We've turned over everything that exists. We'll look into it. We'll make sure we get it, right? It's a lot of amorphous things that happen in these cases, which this case is they probably have turned it over and it's probably all fine. It's just comparing case to case. Almost every defense attorney, almost every defendant is like, we haven't gotten this. And almost every state attorney is like, we've sent it or we've sent them everything we have. We can't send them something that doesn't exist. It's a very common argument in every case. So don't be surprised. And it's not always nefarious. It's not always as it sounds. Sometimes it's just they accidentally overlooked it. Sometimes they are intentionally doing something. Sometimes they did turn it over and the defense just missed it. So there's all different explanations, but very similar arguments made here as we've seen in so many other cases. Eventually, she says, we'll turn over what we have. And the judge says that obviously that should have been disclosed, is how this conversation ends with the judge. And we're going to jump to the next argument here.
Let me ask the defendant, generally any hearsay is defined as any out of court statement offered for the truth of the matter.
And you'll always hear things like that. The judge has to give legal definitions and explain to a pro se defendant how stuff works because they're trying to get evidence in that is clearly hearsay, and he wants them to figure out on their own why it's not coming in. But we're about to have a back and forth that feels like a law school class between this judge and Lori Vallow.
Asserted, the state is referencing what are definitely out of court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you...
She wants to get in statements by Tylee Ryan and by Alex Cox. And she wants to use those statements in her defense. And the judge is saying, how are they going to come in? Why are they not hearsay? Let me explain to you what hearsay is.
Let's first talk about Alex Cox. How do you think the statements fit into either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing. And obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I did not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
Sounds like it, right? And this is somebody who didn't go to law. First off, hearsay is complicated even for people that, have gone to law school, have passed the class, have taken evidence. They take multiple weeks explaining what hearsay is, and people still don't get it sometimes. So one quick definition of hearsay, it's hard. It's like a brain tease, right? Why are you trying to use this if not for the truth of the matter asserted? And you have to know all the other things and all the exceptions to hearsay about how you're going to get certain things in, and like how to make arguments that no, it's not for the actual truth. It's the effect on the listener, or that it was said, or the next steps. And she makes some pretty good arguments that we're going to hear from, but you can hear how poorly it goes generally for people that don't understand hearsay. And she can't say it's an excited utterance or whatever. These exceptions to hearsay, she's not going to make all the arguments, but she does make some. So it's about how you think it would go.
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter
I don't know if it was true, Judge, what they're saying. It's like, that's not the point. The point is you want what they said to be true. You want to use what they said as the truth so you can argue it was true later.
said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So yes, I think they're...
Next steps in an investigation potentially, or what the police did, effect on the listener. Okay, probably not going to fly here, at least to some of them.
For that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804. There's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply to?
Specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements.
Here she goes now. Now she's going to try some exceptions, but she's also got to know the evidence, right? The judge is like, what specific statements? What evidence are you trying to use? So let's use the exceptions with the evidence and try to put it all together here.
Made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So.
And now the judge is going to define what the exceptions actually mean, because they're not always obvious based on the title. Sometimes they are, but I'm not, saying she's dumb or anything like that. This is all stuff we learn in law school. This is all stuff that takes time to digest. You chew on it. You see different fact patterns. You see it in action. You see examples. That's how you start to learn what it is. Then you learn how to make arguments. Take your fact pattern, apply it to these exceptions, apply it to these rules, apply it to these depositions, or to these definitions. And that's how you make the arguments and learn what it all means.
Isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying something
prior.
that he's, okay,
Correct,
so it's not
prior.
a present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
I got to be honest. Better than I was expecting from her, right? Better than I was expecting. Doesn't mean it's going to be a winning argument. Doesn't mean she's going to win a trial at all, but better than you might expect for somebody in her position.
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but.
How long after the incident did he make these statements?
Immediately after, as far as I know.
Well, immediately to some people means 2 seconds. To other people, it means 30 minutes. Tell me what immediately means to you.
You have to know the details and the facts in order to make these arguments, right? If you're trying to say it's present sense impression, you have to know what statements, when they were made, how they were made, excited utterance, again, how they were made, et cetera, et cetera.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. So you're asserting excited utterance. Some of these statements come in. What else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A. So my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B5B, the recorded recollection of his police interview and the body cam footage, applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with,
Yeah.
does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done after 10 o'clock in the morning. We don't.
Are you referencing what time he was interviewed versus the time of the incident?
Let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when the
roughly.
911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded.
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Kylie made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, but the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
All right. Anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to
That's a very good legal argument. It's very true, and it hits to the heart of the issue. You can't benefit from these statements, whether or not they're true, or just use them however you want to, because the person can't show up in court, can't be cross-examined, can't discuss this case anymore because you are the reason they're not here anymore. So you can't benefit from that. And most of the time, judges don't look kindly on that. You're not going to benefit from that.
none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right. The court is on a preliminary basis precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced.
So we're going to hear Lori Vallow make those arguments individually during trial, which should be interesting. No, she's got all the references. She's got case sites. She's got the rules. She knows about the exceptions. She's got standby counsel right there. So I don't think this is going to be somebody who really has no clue what they're doing. And we start talking about expert disclosures. So let's get to this discussion here, because Lori Vallow has an expert that the state didn't know about or doesn't have all the proper disclosures of.
Were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right, expert reports and disclosures are due 30 days before trial generally under the rules. So if you're planning on using that witness, you need to get that disclosed right away. And I may have to take that up depending on what the state's
And this is a situation where defendant gets a little grace, pro se, representing herself.
position is. But
Your
at this
Honor,
point,
that-
it's technically late.
Maybe another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objections. So do you have a record you want to make on that?
Not really.
All right. I don't see any
For
reason
what
why.
purpose? I don't understand.
In the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial, regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that a provisional second trial date now.
That's fine, Your Honor.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take this?
And so they start talking about the two trials, and you're about to hear Lori Vallow get really upset and start arguing, and then realize, oh, wait, is that actually what I want to argue or not what I want to argue, which happens to lawyers sometimes, but even more so happens to clients and people involved in the situation where they really start getting mad until they realize, oh, that's not actually going to be better for me. So maybe I don't want to make that argument. You see that in real time here with Lori Vallow.
The state to
Probably
present
about 3 weeks as well.
similar?
I'm not gonna argue. Your Honor,
I know people are not going to be happy about Lori Vallow and her lawyer laughing, but she's got to be real careful about doing stuff like that in front of the jury.
I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
And she said she's reminding the court the last day is May 11th on her speedy trial because she demanded speedy trial. She got some benefit of the last case in Idaho because they removed the death penalty because the court found a technical violation of speedy trial. And so she's trying to use that again. And she's, dropping that little hint and thread out there that they're going to start that second trial. It better be before May 11th. And again, this is the be careful what you wish for.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once. So it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases.
And her lawyer hits the mute button on the mic so they can have a little conversation. And the state's going to tell us what they think about that.
Not to mention that they did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that.
with a normal defense attorney, and I don't mean that in any way, normally they would be severed.
Severed because you don't want one.
She said with a normal defense attorney, and I don't mean that in any way. And Lori Vallow goes in a derogatory way. It's like, not really any other way to take it. But she's like, basically what the prosecutor's saying is, Judge, she doesn't actually want this. She thinks she wants this. She doesn't want this. It's not good for her. Any defense lawyer would want to sever these because if you know that somebody's accused of not only ending the life of one person, but trying to end the life of another, makes it more likely that they committed the crime, right? It's not supposed to be that way. That's why it's severed, but that's what jurors will normally think. And so now the state's trying to think, can we actually combine these? I guess we could. We could call more witnesses. Eventually, Lori Vallow, a light bulb goes off.
Jury to know about the other
Correct.
two separate charges and have a
Severed.
severed
And I don't mean that in any way. Normally they would be severed.
severed because you don't
Did
want
you-
one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of
Mhm.
the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial, they move back to allow us to get the other witnesses lined up.
That was not, yeah, that's not what I was saying, to combine them.
She's like, yeah, that's not what I was saying. I wasn't saying combine them. It's like, it sounded like you were saying the state had to combine them or they're violating your speedy trial right.
That was not, yeah, that's not what I was saying, to combine them. I'm just saying, give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well,
The court can figure that out. It's like, is it what you were saying?
I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with the time violation, in the sense that you wouldn't be released from custody anyway.
I do think it's a potential issue. So I would basically tell Lori Vallow they can either try them at the same time, or you can waive your speedy trial right for them to try it a week later or whatever it's going to be. But I would be a little apprehensive. The judge is saying no big deal, but speedy trial rights are a big thing. And we don't want to create appellate issues.
And thirdly, the rule for time violations under Rule 8, I think it's 8.6, is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once.
Yeah, I don't know. I would be a little more careful probably, but I think they're going to handle it fine. And I don't think it's going to end up affecting the case, if I'm being honest. And the prejudice of one day is usually not enough to dismiss charges like this. Okay, let's jump to the very last part of the hearing that I want to listen to together. And that's where Lori Vallow is trying to figure out some housekeeping matters with the judge. Where is she going to be able to stand and walk around this courtroom? Is she going to be able to stand up? Is she going to be able to walk to the podium? Is she going to be able to walk up to any witnesses or the clerk? Isn't that interesting? These are very, very, very serious crimes and violent crimes. She's already been convicted of violent crimes. So she should be treated as such, right? This isn't a case where it's a negligent homicide of some sort or a theft case or something that's different. This is taking the lives of not one, not two, but three people and attempting a fourth.
So last week,
Okay.
a week ago. Anything else from the state?
There you go.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial. And
I meant to.
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg thing and the shock vest and all that?
You're going to stick to your table and you can go to the podium. Okay. When you're giving your opening statement.
So she is not going to be cuffed. They are going to have some shock devices on her. She will be able to stand up at counsel table and she will be able to walk to the podium. So she is going to have some freedom of movement throughout the courtroom. I assume they're going to make the state have the same restrictions she has, except that they're going to be able to maybe walk with some evidence that she's not, but that her standby counsel or paralegal will move for her if necessary.
And closing argument, you'll stay by the podium.
Okay.
And if you need to hand a witness an exhibit, your advisory counsel will do that.
And she should ask that the state only be allowed to stand at the podium during opening and closing as well, if that's her restriction.
Okay. Or my paralegal can do that too.
Well, is your paralegal going to be present here designated as your, I guess they could be present. I prefer advisory counsel to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, so I'm gonna be standing there, and if she's sitting here, she's gonna come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it? just
Yeah,
so-
and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium. So
Okay.
anything else?
Your Honor, do you use case lines for exhibits?
No.
All right. And that is the end. The next hearing is on March 18th. If you guys are interested, let me know. Put it in the comments, send me the video, send me any questions you guys have about this case, and we'll continue to cover it as long as there is interest from the people, because that's who we are here for. So make sure you guys hit that like button. Make sure you're already subscribed to our page, or subscribe now if you're not. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.